the defendant having previously been found guilty by jury of count 1, kidnapping, a felony of the first degree in violation of revised code section 2905.0183, count 2, kidnapping, a felony of the first degree in violation of revised code section 2905.01b2, count 3, felonious assaults, a felony of the second degree in violation of revised code section 2903.11a1, count 4, abduction, a felony of the third degree in violation of revised code section 2905.02a2, count 5, petty theft, a misdemeanor of the first degree in violation of revised code section 2913.02a1, and count 7, domestic violence, a misdemeanor of the first degree in violation of revised code section 2919.25a. The court ordered a pre-sentence investigation and report, a victim impact statement, and a drug and alcohol evaluation. The state has had the opportunity to review those reports and is prepared to proceed with sentencing.
All right, Mr. Martinez.
Thank you, Your Honor. May it please the court, Hector Martinez on behalf of Mr. Gutierrez-Reynoso. Your Honor, there is one family member who would like to address the court, so I'm going to have her do that first.
Before we do that, why don't we talk about your arguments on merger with regard to certain counts?
Yes, thank you, Your Honor. So we found sentencing memorandum, and in that memorandum, it's our position that the kidnapping and the felonious assault and the abduction charges should all merge for purposes of sentencing. And I know Ms. Hronek had made some comments in chambers about this and her position. I think clearly, if the state's argument is that this all, they're considering the conduct that occurred at or inside the car, then it most definitely should merge. I mean, this is all within the restraint was for the purpose of the felonious assault. The restraint was very brief in duration in this case. As Ms. Ramos testified, Mr. Gutierrez was on top of her. He was restraining her several times, and the last time he bit her, it was her testimony that he got off of her, left the car, and went right into the house. So if the state's position is that there was just two separate incidents at the car, then I would strongly urge the court to find that that the conduct with regard to the kidnapping and the restraint and the conduct as in regard to the felonious assault are so intertwined that this court must find merger applies, that they're allied offenses, that there's no separate animus. In the cases, I cited a couple of cases, but these cases are very fact-specific, obviously. But in the cases where courts have found separate animus, the kidnapping has been of a long duration, it's been secretive, and it's clearly been separate conduct. So we would rely on our brief as far as the cases that were cited. We would urge this court to find that the kidnapping and the abduction charges would merge with the felonious assault charge for purposes of sentencing this matter. Thank you, Your Honor.
Ms. Hronek.
Thank you, Your Honor. The state's position is that the count 4 abduction does merge into the kidnapping in count 2, however, and that the two kidnapping counts 1 and 2, also merge. However, the state does not believe that the kidnapping and the felonious assault merge for purposes of sentencing. In order for charges to not merge, only one of 3 factors need to be met. And Mr. Martinez mentioned conduct and he mentioned animus, but there's also the import. If cases have dissimilar imports, meaning that they each have a separate identifiable harm, then the counts will not merge. And only one of those 3 things have to be in existence. One of those criteria has to be met in order for the offenses not to merge. As far as the conduct in this case goes, while everything did happen in the car, there was separate conduct that constituted the kidnapping and that constituted the felonious assault. The kidnapping was not merely incidental to that felonious assault. The kidnapping occurred, and through Ms. Ramos' testimony, while the defendant was trying to pull her out of the car by her hair and by her arm, while he was climbing on top of her, while she was trying to crawl away from him in the car towards the passenger seat, all the while he's biting her arm and he's biting her foot, and that biting creating a substantial risk of serious physical harm to her. That is separate conduct from then once that kidnapping has occurred and he's on top of Ms. Ramos in the car and he then bites her face, causing her serious physical harm. Those two offenses are committed separately, and that is separate conduct that constitutes those two offenses. And additionally to that, there is separate identifiable harm that comes from both of these two actions. The harm of the kidnapping is that the victim was being forcibly pulled out of the car by her hair, by her arm. She's being bitten. She's being climbed on top of while she's screaming for help and trying to get away. And that harm is separate from the harm of the defendant then biting her face and causing the actual wound and the scar. Those are two separate identifiable harms that we have here. So based on that, Your Honor, the state does not believe that the kidnapping and the felonious assault merge for purposes of sentencing.
All right, so the abduction on 4 and one of the kidnappings are going to merge. So those 3 counts will merge. What count are you proceeding on with regard to the 1 or 2?
Count 2, Your Honor.
Count 2. So count 4 abduction will merge into count 2, as will count 1 kidnapping. Pursuant to the applicable case law and the testimony in this case, I'm going to find that count 2 and count 3 do not merge. So we'll proceed on counts 2, 3, 5, and 7. Okay. Go ahead, Mr. Martinez.
Thank you, Your Honor. As far as in mitigation, we do have one person who would like to address. I'm going to ask her to introduce herself and address the court at this time.
All right, just please rise and state your name and tell me whatever you want me to know.
So under the low fella, I am Damien's aunt, and I have an 8-year-old who's very affected by what's going on right now. He was not able to be present, and as if you allow me, I want to record set.
Okay.
Hi, my name is Joel Sovolo. I am Damien's little cousin and best friend. He was always very nice to me, and he was always good to see. He loved me. I love him very much, Damien. Love Joel. And I just want you to know that because he's a huge impact in our family. And one thing he did was not something that defines him and the person he is, because we all know he's not that person. Thank you.
Thank you.
Your Honor, everyone here today is in support of Damien Gutierrez and in the sentencing hearing. With regard to the sentencing factors in this case, Your Honor, the factors in 29, 12B, as far as the more serious factors, we would respectfully submit that in every felonious assault case there's serious physical harm, that this case is not more serious than the average felonious assault case, nor is it more serious than the average kidnapping case. And we would urge this court to run any sentences concurrently with regard to the felonious assault and the kidnapping. Obviously, Ms. Ramos did suffer serious physical harm. We never denied that. My client suffered serious physical harm, and again, it's inexplicable how he suffered that serious physical harm. Ms. Ramos testified that she never testified that she struck my client. She testified that these were self-inflicted wounds. I think we're just glossing over what happened here, but it's clear that my client was assaulted by Ms. Ramos at some point during the evening. As far as all of the other factors, we would concede that his relationship with Ms. Ramos did facilitate the offense as to whether or not this would be a more serious felonious assault and kidnapping charge. With regard to the less seriousness factors under 29.12C, we would respectfully argue that the victim, Ms. Ramos, facilitated or induced the offense. She went over to the house. No one forced her to go over to the house. It didn't come out in trial, but one of the officers, when he was asking her about Mr. Gutierrez following her or texting her, he asked her point blank, "Why did you go over to the house?" I mean, it's inexplicable why she went over to the house. Also, we would argue that the offender, Mr. Gutierrez, acted under strong provocation. Again, going back to his injuries, his broken hand, clearly he had injuries all over his face and torso. With regard to the recidivism factors, Your Honor, we would argue that none of those would apply here. Or, I'm sorry, let's just go through the factors. He was not under release from confinement when he committed this offense. He was not adjudicated a delinquent child prior to this offense. He has demonstrated a pattern of drug and alcohol abuse that's related, but he does acknowledge that the drug and alcohol use contributed to this offense. Judge, he would have never done this had he not been under the influence of drugs and alcohol. They were both impaired that night. What we respectfully submit happened, there was fighting between them. Damien obviously went, above and beyond what he should have done and bit Miss Ramos, possibly because she was hitting his broken hand, possibly he was in a lot of pain. I talked to Damien. He never would have done this had he not been under the influence of drugs and alcohol. He was on bond to this court. He has stayed clean since the day of this offense. He's proven to this court that he can stay sober. The letter that he wrote to this court, he wrote that letter. He handed me that letter. Normally I'm talking to people about, write the letter. Damien wrote that letter. I didn't have any part of that letter. He's indicating to this court he knows he had drug and alcohol problems. He knows that he needs help. He's willing to get that help. He's willing to go through whatever treatment this court would impose. Also, he does show genuine remorse, as indicated in his letter to this court. He did also write a letter to Ms. Ramos, which I provided to the victim's representative, Gladys, to provide to Ms. Ramos, indicating that he was very sorry for what happened, that he wishes her nothing but the best in her future endeavors. As far as the less recidivism factors under 292912E, again, he has no prior juvenile delinquencies. He's not been convicted of any criminal offenses. This offense was committed under circumstances not likely to recur. These two are going to go their separate ways. I think in the letters that were submitted to this court, initially, the first letter there's a letter here from Laura, Damien's current girlfriend. So Damien is now dating this other girl. She has a 4-year-old son. He shared everything that happened with him, with Laura. There doesn't appear to be any violent incidents prior to his relationship with Ms. Ramos or subsequent to his relationship with Ms. Ramos. And as this court's aware, oftentimes when you get somebody in this court for the first time on a felony case, they have prior incidents, especially in juvenile court. There is nothing in Damien's past that indicates he's a violent person. In fact, all the letters from his family and friends indicate he is a nonviolent person, that he loves being with the children. He loves being with the family. He's not a big person. He obviously, some of the letters indicated he was born premature. He was always a small stature. He's just not a violent person. He doesn't engage in fighting with people. He doesn't engage in fighting. This was just a toxic relationship, and it's not likely to recur because he's not going to be with Ms. Ramos moving forward. And again, he does show genuine remorse for what happened. As it relates to his substance abuse and mental health, I would note that Dr. Rinsberg did complete a psychological and substance abuse assessment with Damien. Dr. Rinsberg had ordered Damien's records from Crossroads. As the court's aware, Damien did treatment at Crossroads when he ran away briefly when he was 16, I think, and then he continued that treatment for some period of time. He stopped when he was 18. He went back to using drugs and alcohol. He knows that that's not a path that he needs to be on. Again, another factor that this court should consider is the fact that Damien, his father's been out of his life. His stepfather, Julio, has stepped in, but he's had no relationship with his father. Again, it's not an excuse, but it's something that needs to be taken into consideration by this court. Dr. Rinsberg had relied on the Crossroads evaluations to indicate that Damien suffered from ADHD, an unspecified disruptive impulse and conduct disorder, and cannabis use disorder in early remission. Dr. Rinsberg indicated that Damien would benefit from jail treatment. He indicates that Damien's age, he has a good prognosis for him moving forward just because of his age and the fact he has no prior criminal history. We would ask the court to appoint Damien appellate counsel in this case to represent him if he wants to pursue an appeal of this matter, as he's currently indigent and not able to afford counsel. I guess, in summary, Your Honor, Damien grew up in a loving family here. You heard from his grandmother, you heard from his mother. The grandmother's the matriarch of the family. These are hardworking people. This is a close-knit family. These are people that will look out for Damien in the community. He's not a danger to the community. He's a danger to Ms. Ramos. They were a danger to each other. And again, I noted in my sentencing memorandum, I asked Damien, we met dozens of times before trial. I asked him countless times, how many times did this happen? How many times did this happen? Finally, he indicated some of those events that had happened. And then as we were getting close to trial, I asked him again because I would keep pressing him. He told me that it happened more than 20 times that she would attack him. So what I think happened here is Damien was in a violent relationship. And yes, it takes two to tango here, Your Honor. But the police were never called. He was showing up with scratches and claw marks at family events. The family was saying, well, what are you doing? Why are you in this relationship? And I think he was embarrassed that he was in this relationship. You can't imagine when you're in a violent relationship what that feels like, what you should do to get out of it. He's young. He loved her. He testified he loved her. I believe he loved Ms. Ramos. He wishes for nothing but the best for her. And I truly believe that Mr. Gutierrez is not a danger to society. He is amenable to community control sanctions. He can be placed in Lake County Jail for a term. He can be given drug and alcohol treatment. Dr. Winsberg indicated he needs some psychological counseling as well. He's ready, willing, and able to do all that. He has the tight-knit family behind him, which so many defendants do not have. So we would argue that the presumption of prison has been overcome. And should this court determine that a prison term is appropriate in this matter, we would respectfully argue that the minimum term would be appropriate in this case. There's nothing that makes this more serious than the average felonious assault and kidnapping case. It is truly a felonious, it's a domestic situation that evolved into a felonious situation. Yes, he bit her. I know the fire chief got up here and said it was one of the worst bites he's ever seen, but at the end of the day, he let go of her from the bite. Yes, she has some minimal scarring. He feels badly about that, but he did let her go. He did get off her and retreat into the house. His actions after the fact, if he would have just called the police, maybe we wouldn't be here. If he would have just walked out and talked to the police, maybe we wouldn't be here. He didn't cooperate. He should have done that, looking back with the benefit of hindsight. And I think a lot of this was because he was under the influence of alcohol and drugs that night. And so we would argue that nothing makes this more serious, that he's entitled to a minimal prison term in this case. And we hope the court would see it as we see it, that this is an unfortunate situation, that he was all precipitated by Damien being under the influence of alcohol and drugs of abuse that night, and he's not a danger to the community. The community does not need protection from Damien Gutierrez-Reynoso. What we need is Damien Gutierrez-Reynoso to have treatment.
Gutierrez, is there anything you'd like to tell me before I impose sentence in this case?
No, Your Honor.
Right. And that's because he's going to appeal the case.
Yes, he's standing on his letter that he wrote to Your Honor.
All right, Ms. Ronick.
Thank you, Your Honor. The charges here are felonies of the first and second degree, so there is a presumption for prison in these cases. And in order to rebut that presumption, a court must find both that community control would adequately protect the public and punish the offender based on the recidivism factors, and that it would not demean the seriousness of the offense because of the seriousness factors. Mr. Martinez mentioned a couple of times that there was nothing about this felonious assault that makes it more serious than any other felonious assault. The state strongly disagrees with that statement. Yes, the EMT supervisor said that this was the worst bite that he's ever seen. The bite was to Ms. Ramos's face, And the scar was to her face. It took weeks to heal. Photos were introduced at trial of that healing process. And every day when Ms. Ramos has to look in the mirror, she has to see that scar and think about what happened to her. And every person that meets her sees that scar. And she's thinking about that as she's meeting someone. And she even testified that people have commented on the scar and that someone thought she had ringworm, and that really affected her. So this certainly is more serious than other felonious assaults. And then to address the less seriousness factors, the fact that Ms. Ramos went over to the defendant's house does not mean that she induced or facilitated the offense. She didn't induce or facilitate the offense just by being there and being present for him to commit this offense against her. And the testimony at trial supports also that she did not induce the offense by attacking the defendant, that the defendant was not strongly provoked. The defendant himself told the police that he broke his hand himself, that was a self-inflicted wound. And so the seriousness factors clearly do not show that community control would not demean the seriousness of the offenses. And as far as the recidivism factors go, yes, the defendant does not have a juvenile record, a violent record. Yes, he does not have an adult record. There are other factors that are important here. And it's the state's position that the defendant does not show any genuine remorse. To this day, he does not take responsibility for what happened at trial and still in the pre-sentence report. And still today, he's claiming that the whole thing was Ms. Ramos' fault and that he was just trying to defend himself and everything that he did to her was warranted. That is not having genuine remorse for what happened. And I would also submit that this offense was committed under circumstances that are likely to recur. The defendant was drinking at the time. Mr. Martinez says that this would never have happened if he wasn't drinking. And the defendant says that he's been drinking since he was 16. His use spirals out of control. He often blacks out. And the defendant also told Dr. Rinsberg that he has an anger issue, that he has a history of getting physically aggressive when someone says something bad to him. I mean, he himself says that he's physically aggressive. That is something that is certainly likely to recur in the future. I also want to mention just other relevant seriousness factors that the court is able to consider any relevant factors. This case is very serious. The defendant chased the victim. He terrorized her. He was unlocking the car door. She was trying to lock him out. She was screaming for help, honking a horn, trying to get someone to call 911. And he continued to attack her while she was trying to crawl away from him in her own car. The conduct is outrageous, that conduct. And then he bit her hard enough to not only break the skin so dramatically, but to cause permanent scarring. That is animalistic. This is different than just any other felonious assault or any other kidnapping. The state believes that the presumption for prison has certainly not been rebutted, that a community control sanction would certainly demean the seriousness of the offense and would not adequately punish the offender, that it's just not, community control is just not appropriate or lawful based on that presumption for prison. The state is asking that the court impose a prison term of an indefinite prison term based on Senate Bill 201 of 5 to 7.5 years.
Thank you. I've reviewed the pre-sentence report, the drug and alcohol evaluation, the victim impact statement, the sentencing memorandum with all the attachments provided by Mr. Martinez, the letter from Mr. Gutierrez. I sat here and listened over the course of about 4 days with this trial, and I understand there were two versions of what occurred by Mr. Gutierrez and by Ms. Ramos, and the jury heard two, and we decided which one occurred. So that's why we're here. Now, it's quite apparent to me, whatever happened in the upstairs in the bathroom, whether it was Ms. Ramos beginning the encounter with Mr. Gutierrez or vice versa, that at some point shortly after that happened, she left. She ran out of the house, followed by Mr. Gutierrez. She ran to the car, got in the car. He came out and pursued her. His reason given was he didn't want her to drive away, but he had the key. So This all could have ended on the second floor had Mr. Gutierrez maintained his cool and not pursued Ms. Ramos, because from there, some very serious injuries occurred. And that scar, when she testified on October 3rd or October 4th, I still see it. So it's a permanent scar. And she was bitten by the evidence on the face, the arm, the stomach, and the foot. So you were completely out of control, and it never had to happen had you never left the second floor and let her leave. And if you were truly concerned about her being able to start that car without the key, then you could have called the police and told them. There's a bunch of things you could have done that you didn't do, and the result is now you're sitting here with a conviction for kidnapping and a conviction for felonious assault. I've considered the applicable statutes, those being 29-29-11, 29-29-12, and 29-29-13. I've reviewed all the factors and I've considered all the requirements set forth in those statutes. There is a presumption that a prison term should be imposed, and the facts in this case indicate that you have not overcome that presumption. So the sentence of the court is on count 2, a definite minimum term of 4 years to an indefinite maximum term of 6 years. On count 3, a definite minimum term of 4 years up to an indefinite maximum term of 6 years. On count 5, a term of 180 days in the Lake County Jail. And on count 7, a term of 180 days in the Lake County Jail. You have credit for 45 days that you have served. I'm going to, the counts, the 4 counts will run concurrent to one another. And when you are released, you're going to be on post-release control for 5 years under the parole authority. They will place conditions on you. If you violate their conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If the violation is a new felony, then you could get an additional consecutive prison sentence for that violation, the maximum of which would be the greater of 12 months, or the time you have left under your 5 years of post-release control. You have a right to, there's also restitution. I'm going to order to Michelle Ramos in the amount of $985. You have the right to appeal your conviction and sentence at the 11th District Court of Appeals. You have a right to have a lawyer represent you in that appeal and to have a notice of appeal timely filed. You also have a right to if you can't afford a lawyer, one will be appointed, and I will appoint you appellate counsel. You have a right to have the transcripts prepared in this case to assist you in pursuing your appeal. If you can't afford the transcripts, they'll be given to you at no cost. I will appoint the public defender to represent you in the appeal.
Thanks for watching. If you follow real courtroom cases like this, leave your thoughts in the comments and subscribe for more authentic court proceedings.